do you personally have the psychological background and education? So in the US, it is common in the family arena for mediators to be psychologists. It is not so common in the civil arena and the commercial arena that mediators will be psychologists. That said, I know I personally have spent a lot of time trying to understand the human mind. Because
Good luck.
Of course, because as mediators, we are dealing with humans. I had a friend who told me, oh, you're more like an artist than a professional. And what I took from that was that as an artist, my medium was not paint, it was people. But as an artist, in order to understand my medium, I really had to understand people. And so I spent a lot of time learning about psychology, but particularly learning about neuroscience, because as the field of neuroscience grew, we were able to get insights into the mind that actually were more accurate and deeper sometimes than the field of psychology offered. And so I learned a lot about how it is that we as human beings operate, what helps us make decisions, how we as mediators can connect with the people that we work with. I think that my level of depth into this topic is related to what we talked about before about being a naturally curious person. I don't think that all mediators have necessarily invested that much time and energy in that, but I think that we all really feel that even if we don't have a psychological background, that it's important to be able to have some of the insights and some of the skills that the field of psychology offers us. And I don't know if you guys want to answer that question.
Yeah, I would certainly, if I may. I agree completely. And I think to the extent that we have, whether it's through study or through our own instincts and our sensitivities, that's a critical aspect of being a successful mediator. And there's a whole development in the United States about the neuroscience, if you will, of mediation. That is understanding the way the human brain works and reacts to conflict and to resolution that really has developed in a sub-area of mediation that many mediators feel are tremendous insights and techniques in terms of how, in a genuine way, to move the parties to resolution, not to manipulate, not to use these psychological techniques and insights in a way to manipulate the parties, but to help understand what really is an empathetic form of behavior and compassion, and what really is active listening, where you do listen in a meaningful way to move the parties towards a resolution. So I think these are extraordinarily important. And we as mediators, at least for me too, Claudia, it's a continuing education process to try and do it well.
Yeah, thank you. So on to just to continue and finish up with the selecting a mediator. Vic mentioned before the break that if you have a client who you think is unrealistic about the value of their case, you might want a very evaluative and very directive mediator. If you have a client who is very upset and you think that one of the things that will help your client get less upset and be able to really start grappling with their legal problem, you might want a mediator who is more elicitative and somebody who really is more likely to be able to have the patience and the kindness to be very empathetic with your client and really take the time to listen to them and to help them really let go of some of the difficult emotions that might be hindering their ability to reach a resolution. Likewise, if what you can really see is that what's important in the resolution of the case is the relationship between your client and the opposing client, then you really also might want to be looking at a more elicitive mediator who has a broader focus. So how you choose the mediator really is dependent on who your client is, what the dispute is, who the client is on the other side, even who the lawyer is on the other side. And so you may very well want to use mediator A for one purpose and mediator B for another purpose. And I think, what Vic said before about the kinds of efforts that you will want to go to really understand who that mediator is will really be helpful to you in matching the mediator to the case.
I guess the one piece I would add is that I think that the very best mediators have skills across in many of on all ends of the spectrum, but most of us have a kind of a default where we feel most comfortable. But there certainly are plenty of mediators who have very strong elicitive and empathetic skills, and also can provide the firm legal assessment when and if that's needed. So I just, it's not an either or proposition.
No, an excellent point. And when I worked at the court, we didn't allow people to choose their mediators. The mediator would just be assigned the case randomly. I felt like all the mediators were super top notch. And as Howard said, very flexible along both of the axes we looked at, the directive elicitive axis and the narrow broad axis. And so they were able to essentially customize each case and provide that particular case with whatever skills were needed in that moment. And of course, if you can find mediators like that who have that flexibility, then I think you're really sort of the best served to have a person who's got skills and temperament in all sorts of directions. So anything else?
Yes, I do. I want to add to that.
Yeah, please.
And just emphasize your role as a legal advisor is to have that as a full and open discussion with your client, because you're going to make judgment about whether your client, in terms of the style of mediation, is suitable for one form or another of a particular mediator's reputation and style. And there's nothing worse than a lawyer, an advisor, going in thinking this is in the best interest of their client, but the client is not bought into that kind of approach at all and is not well prepared. So making sure that all those expectations are lined up, the more they are, the more satisfied will be your client. And I may be giving that demonstration, an example of where it didn't happen that way. The better those are lined up, the more likely you'll have a happy client and you'll get a better result.
Yeah, excellent. So any questions that you have particularly about mediator selection or the qualities of a mediator?
We're not seeing any on our side. Are you picking up any on yours? No.
No.
Okay.
So I think we should move on to the next topic, Vic.
Yeah, let's move on.
I think this goes to the presentation
Yes.
of lawyer advocacy in a mediation. So let me share an anecdote. I like to kick this off because it's a little bit self-effacing, but very true. In my first mediation when I was continuing my work as an advocate, I was invited into this mediation. The case involved an age discrimination matter. My company and my client, my executive, was accused of wrongfully terminating a person because of their age. And the company, as you can imagine, the first line supervisor in the company, they felt they documented very well this person's poor performance. And when they decided to terminate this person, who happened to be around 64 years of age, which in our society is getting on in the elderly years, they felt they were totally justified. And they were absolutely livid that they were being accused, this enlightened company, of age discrimination. The plaintiff side, of course, the plaintiff's lawyer, they felt this was a good worker, had not been criticized in any kind of what we call progressive discipline, a fair way of notice. And as far as they were concerned, there was no reasonable basis to terminate this person, and it was because of their age. They wanted to get this older person out, and in fact, a younger person, 20 years younger, was hired to replace them. So I said, let's try mediation. And I went into mediation, and the adversarial skills came out, the fangs came out of my mouth, and I went after, in the opening statement, I went after the plaintiff, and I said, now look, you know better. Let me tell you why there's no merit to your case and why this is unjustified to accuse the company. And I laid out and lambasted. I said, I showed the progressive discipline. I showed the fact that the person failed to meet the new standards that have been set up, that they've been given the warning several times, verbally and writing, and only after that opportunity was that individual terminated. And I felt, wow, I had done this really bang-up job, terrific job representing the client. I looked at my client, and my client was just delighted that I really laid into this person. And the mediator sat there looking completely askance, completely frustrated and stunned by what I had done. And he took me out into a private discussion, just the two of us. And he said, Vic, this is a mediation. This isn't, you're not in trial right now. You've angered that other side. They're going to be so disinclined to reach a resolution. They are so angry and emotionally upset. And this was a sobering moment for me to always remember, is now I've gone into mediation, how important it is to understand what the role is of the mediator as an advocate. And I'll do this briefly, and we'll see if there are any questions coming. But your skills as an advocate in court to convince a judge, or if you have a jury, but a judge, that your case is the strongest and deserves the award that you want, is very different. In that mediation, your goal, if you will, I like to say, is going beyond right and wrong, legally and factually. Yes, that's important to present your client's case, but it needs to be done in a way that is not attacking the other side in such a way that the collaborative effort, the collective effort, is not being made or let me state it more positively. The collective effort is being made to reach a resolution, recognizing that the other side has their own legitimate concerns, as in most cases they do. Most cases, they're not acting out of malice or bad faith. They feel they have been damaged in some way genuinely. And of course, your client feels they've been wrongfully accused of some misconduct that justifies this defense that you're putting together. So what I want to say by way of advocacy is it is really important for you to have that discussion with your client in advance so they understand why you're taking the approach that you are. Otherwise, if you go in there in a more collaborative way, they may feel you're not aggressively defending and presenting their case, and be really confused about what's going on. And their mindset will be very counterproductive. On the other hand, you will lose the opportunity if you're too aggressive to bring the parties to a resolution. So the bottom line of all of this is what you want to be able to do is present your facts and present your law in a very civil way without attacking the other side with the full venom of one's anger or frustration that the client may feel that they are being wrongfully charged with some unlawful action. And what we do in lawyer training, and I hope that this is somewhat familiar, if not very familiar to all of you, is we talk about how a lawyer can go in, present the facts as positively as possible, present the law where it's appropriate, present the arguments, but do it in a way that is respectful of the other side, but brings out the strongest elements you can to help persuade the other side. They need to come down in their expectations and demands, and also be more constructive in terms of what your offer is going to be from your side in accepting the resolution. So the bottom line of all of this in the presentation is it is not going for the jugular. It is, in fact, laying the groundwork so that the side understands the strength of your position, empowers the mediator to use those strengths to convince the other side to be more accepting of your position, and respectful that they will be doing that in turn to you, and you deal with your client in an understanding way rather than a feeling, why did I ever hire this lawyer in the first place if I'm not more aggressive? And I think that really summarizes the basic point that I want to make about this. I welcome Claudia and Howard to add to this if they wish.
Well, I wonder, Vic, if you would be willing to demonstrate to them what it is you should have done instead of yelling at the client and the client on the other side and telling them how terrible they were. I wonder if you would be willing to demonstrate for them what you should have done.
Sure, I'll be glad.
Okay.
I'm going to do it in a very short form.
Sure.
Yeah.
Understand it'll take more time. So instead of going in and attacking the person with the venom, this would be my kind of opening statement to them on the issue. Assume it's an age discrimination case. And I've heard what they had to say. They presented that case. And I would say, Mr. Plaintiff and counsel, I really appreciate the genuineness of your belief in your case. And I understand that you feel both emotionally as well as legally that there has been a wrong here. And I want you to know that we, our client, respect that. And in fact, I can say to you in all candor, we're sorry that you feel this way and that you feel this pain. This was never intended. But you need to understand that from our perspective, we feel we have proceeded in a way that is not only lawful, but has been very respectful. And from our perspective, we laid out a course of progressive discipline, which I'll describe to you in a little bit more detail than I'll do now, a little bit more detail of how there was a verbal warning, a written warning, a final warning. We wrote down the areas of performance that we needed improvement. We're also going to show that there are other people in the company, in your age group. In fact, a substantial amount of our workforce is made of people your age and older who continue to be very successful in our company. So I hope, I doubt it's going to convince you that we're right and you're wrong, but I hope you'll understand this is a legitimate perspective, as I understand that yours might be, and we can work together to see if we can work a resolution out that allows you to move forward with your life and allows us to continue with what we think are the legitimate policies in our company. So with that in mind, I hope we can work together to a resolution. And if you have any questions you want to ask of us along these lines, together or in private discussion, we welcome them. That's the approach that I would take.
Thank you.
Okay?
I want to note a couple of things that you did and just draw them to everyone's attention. The first, it has to do with the fact that you began with an acknowledgement of the other side. And you wouldn't necessarily do that if you're making this argument to the judge, not at all. But the importance of where you began, which is just acknowledging and respecting that you heard their position, you heard what they had to say, and that was the beginning place. You actually, the second thing you did was, you didn't apologize for what the company had done, but you apologized and acknowledged that the plaintiff felt hurt. And that also, I think, was a very important component of what you were presenting. And then third, you really provided an invitation to the other side to acknowledge that you see it differently, but that you wanted to be forward-looking. What you didn't do is just be nice. I mean, you weren't compromising your point of view. Mm-hmm. So with a civilized tone and with an acknowledgement of respect for the other side, you were still able to say, but it's important. You didn't soften really. You might have softened the way in which you said it, but you didn't soften the actual position mm-hmm. that your company what was taking. And I think those are important benchmarks of the difference of good advocacy inside a mediation process as compared to the sort of advocacy that you might engage in court.
Mm-hmm.
I don't know if there's other things that you saw or particularly want to highlight, Claudia.
I thought that the tone was very measured. It was both assertive, but it was also, I'm not going to say it was kind, but it wasn't unkind.
Mm-hmm.
And so I would feel, if I were the client, I would feel like I was if I were your client, I would feel like I was well represented. And if I were the party on the other side, I would feel respected.
That's the key word.
And so
Right,
I think that in really striking the balance between assertion of your own side and empathy towards the other, you really struck a tone that was kind of right in the middle there.
Mm-hmm.
And I would assert that this sort of advocacy is actually harder than advocating in court. It's more complex, and it's a challenge for the parties' representatives who are engaging in this kind of advocacy,
And the clients,
and
too.
for the clients. It is not because you're really trying to appeal to multiple audiences at the same time. So this isn't soft. This is hard, and it's really and it is important skill for you as legal advisors to really try to develop. And it's not something that it's something that has taken years in the U.S. for people to really understand and recognize is an independent skill. And not all great trial lawyers are great at this.
And I think it's largely because so many lawyers are bad at this, and so many lawyers start out the mediation the way Vic did originally, that many mediators don't want there to be any kind, mediators in the US do not want there to be any kind of joint session,
Mm-hmm.
because they're worried about exactly what Vic did, that right out the gate, he's going to piss off the other side so badly that it's going to be unrecoverable from, and that there's instead of narrowing the breach, it's going to increase the breach between the parties.
And I want to emphasize, as we kind of close out this area, to you as legal advisors, that it's critical that you prepare your clients for this, because if you just go and do this, they very well may feel you are underrepresenting, under advocating for them, and they will interpret it as being too soft, if you will, in terms of what that presentation is. And I think your client's understanding that you, as you may recall, there was reference to that earlier, that you're going to be tough on the issues, but soft on the people, that this approach is so uniquely well suited to the mediation process and will help them get to the resolution they want today or whatever it is in the mediation. And if your clients understand it, then that is going to allow you to do the best possible job.
So I'm going to just add on here. I actually think one way of thinking about this is as a potential business opportunity for yourselves, because at least again, in our system, as it has developed, there are lawyers who have now developed a reputation for being particularly strong advocates inside the mediation process. And they're sought after as lawyers as good representatives of their clients when their clients are seeking a resolution. So this is actually, to become good at this sort of advocacy, you can think of that as a business opportunity for you as a legal advisor to develop a reputation of being really good at this kind of advocacy.
Yeah, that is such a great point, Howard. And I will tell you, in my firm, I think I may have mentioned we had 350 lawyers and 120 some odd litigators. There were certain people that were capable of doing this. They could go in and they could do both. They could be the very aggressive advocate, but they could also be of that mindset as a mediator mentality of knowing how to go beyond the advocacy role in terms of the hard advocacy to move the parties to resolution. And there are other lawyers who are absolutely terrific in court who just don't have that ability to stop being so aggressive. That's the way they were trained. That's what they do professionally. And frankly, that's what they felt comfortable with. That's what they wanted to do. And these were not people that, of course, we in our mediation and arbitration group in our firm, these were not people that were invited into the group or trained in the group. And they were happy not to do that and just stay on the other side of the more hard litigation that was involved. So I think these are judgments depending on the size of your firm, be it small or larger, how many people you want doing it and whether they're trained, and most importantly, whether their innate capabilities, potential or actual, are suitable for this kind of a role. That's important for you as a legal advisor to keep in mind.
So should we open to any kind of questions about this
or anything else?
Or anything else? And I think there is one question that was raised earlier in the day that we didn't get to, so maybe we can have that one put up on the screen to get us started. But while we're doing this, please think if you've got any other questions, that this will be an opportunity to raise them on anything we've talked about or anything else that you would like us to address. So this is, when it comes to mediation knowledge, mediators knowledge, the problem begins when the parties, without a lawyer, suggest a solution that the court will not approve. If the mediator doesn't notice the problem at the stage of concluding settlement, the parties won't be satisfied with the result of the mediation. All right. So I guess this goes to the question of the courts, like, will the court not approve a certain settlement, and have you wasted everybody's time by not taking this into account?
Right. And for us, we look to the lawyers to be able to be the ones to say, this is an agreement that complies with the law. We don't see it as our job as the mediator to necessarily make those determinations. And I understand in your hypothetical that the parties aren't represented. What I would do if I had unrepresented parties as the mediator, I would say, please go and have this reviewed by a lawyer to make sure that you're not giving up any rights that you don't want to give up, and that this is generally something that complies with the law, if you want to have it be approved by the court. But I don't see it as my role as the mediator to be making those pronouncements.
So I think to me, and I agree with Claudia's comments, there's also a question of degree. It seems to me, if there is something that is blatantly against either public policy or the law, and the parties are insistent on provisions which would be violations, my feeling would be to basically inform them of that problem in the mediation. And if the agreement has to be submitted to the court, then they may need to hear it from the court in terms of its fact, and they won't be satisfied until the court tells them that because of these provisions, it's problematic. Go back to the drawing board. I like, as I'm sure all three of us, to avoid that. I think we want to encourage whatever is brought to the court to be something that we believe is in compliance with the law and public policy. Sometimes it's not black and it's not white. Sometimes there may be some areas that you're not quite sure how the court is going to react. I'll give you an example of this. One of the big issues I find in my work in employment law are what we call basically confidentiality and non-disclosure provisions. From a company perspective, I most often want a clause in the settlement that says the parties are not going to disclose the results of this settlement. The only thing they're going to say is that they reached, we usually word it, an amicable resolution. And where you have situations of serious claims of discrimination, sexual harassment, violence in the workplace, claims of employee theft or fraud or embezzlement, and so, or serious corporate misconduct involved in some of these cases. That could be offensive to a court, that there's not going to be some public statement about the content of the resolution. Now, that is not the case in most cases. In most cases, it's not of such a high public interest that pressure is there. So it's okay. There are some judges, again, in my experience, not the majority of judges, that feel it's important to be more public about these things, and they tend to review more, I think, than they should, the fairness of the case. In any event, this is something that you really need to be prepared for in terms of counseling your client. And if you get up in those gray areas about whether it is legally enforceable for either public policy, legal legislation requirements, or the like, then you want to give careful thought as to whether or not this is what you want to take to the court for approval.
I should probably just note that in our system, unlike yours, it is the exceptional case where the court has to approve a settlement. And typically, our settlements that are reached in mediation are simply private contracts, essentially, and they do not need to be reviewed by the court. So it is quite a different. Our practices are quite different than the situation that you face here in Poland, where things do need to be submitted to the court for approval. And it may be that in your context, this, particularly when parties are unrepresented, it may drive the selection of the mediator process to be one in which the mediators are going to be able to help the parties to tell the parties, or to ask questions at least of the parties, if it looks to the mediator like the parties are coming upon an agreement that the mediator, as a fair sense, won't be approved by a judge. You would want to raise that as the mediator, and you'd want to be sure that you have a mediator who is going to be knowledgeable enough to identify this as a potential problem when they're working with people. So this is a way in which, your system may be sufficiently different from ours that it drives a different set of needs around mediator selection in certain contexts.
One of the three things that I found most commonly in representing clients now, not as a mediator, but representing clients, when we go before the court after we've reached an agreement and we present that to the court generally wants to know three things. One, and we'll ask the parties, is this an agreement you voluntarily entered into? Two, did you have counsel or the opportunity for counsel, so that they know they had the right to counsel if they wanted? And three, was there any other basis that you felt there was some coercion or fraud that was being perpetrated, something that was, to put it bluntly, dishonest or in some way faulty about the process, that this is not something you really want going forward? And most judges, when they ask those three questions, pretty straightforward. Usually we come in with our clients, with counsel, and we're seeking under our system to have the court turn the settlement into, in effect, a judgment, so that once it's approved by the court, you can no longer litigate the underlying dispute. The only thing that can be litigated after you present it to the court and the court turns it into an order is whether people are abiding by the judgment, or by the order which is turned into a judgment. And this works really effectively to bring, and that's the beauty of the process, to finality. And it is rare indeed under these circumstances that we see people are fighting about their agreement, because it's truly voluntary to begin with, and it's very effective for that reason.
Other questions about anything we've discussed through the course of the day, or anything else that you're just curious about and wish to ask us? Right.
Okay. Well, we want to thank you for your patience in participating in this as a Zoom conference. Without an exception, we have a person that has appeared, which has been delightful. But we're delighted to have the opportunity to come here to Poland and to Poznan in particular. We're falling in love with this city, and to speak with all of you as legal advisors in your very important roles. And is that a question up here?
Okay, is such settlement final? Or
Okay. All right. Good.
Fine.
Good.
What does the question mean by such settlement? I'm not. Could the questioner clarify?
And if not, we can make an assumption in the question.
I mean, if the meaning is a settlement reached by the parties at a mediation,
I hear settlement,
the
the
result of
mediation.
mediation. So if a settlement, so this is how we usually do it at the settlement or the mediation, settlement is reached, either the lawyers have already brought to the mediation a form of settlement where they have the releases and sort of general terms, and then they fill in the specific terms of this agreement, usually monetary, non-monetary, time deadlines, and it's signed then and there. And the agreement recites that the parties intend to be bound by this agreement. It is final, and it really cannot be challenged. However, if the factors that Victor mentioned, if somebody feels that they have been coerced into signing it, so not on the four squares of the contract itself, but the conditions of reaching this settlement, they can try to undo it. I would say, because of the confidentiality of the mediation process, mostly they are not successful in doing so. That doesn't mean that some people haven't tried after the fact to undo it on the grounds that they weren't well represented, or they perhaps were coerced by the mediator into signing it. But one of the things that we didn't talk about in this program is confidentiality, and the strict confidentiality of the mediation process, which makes it hard then to challenge after the fact the process by which the mediation agreement was reached.
And the content too. And I want to emphasize this.
Please.
This is a really important point. In our system, it is not appropriate for a judge to independently review the terms of the settlement for fairness. That is not the role of a judge. If a judge has reason to believe the terms of the settlement violate public policy or the law, that is appropriate for a judge to explore, if necessary. In most cases, the lawyers come and represent that it is in compliance with the law, if there's any question at all, and public policy. A judge can explore that. But, and this is really important, because this is not true in many other countries, and it's just so demoralizing. For example, in India, the judges have a tendency to look at the terms of the settlement and start all over, taking a fresh look at what they think it's fair. And here we are, a mediation took place. The parties have reached this after a very hard effort that they're willing to go forward. What business does a judge have, unless it's a question of law or public policy, of interfering with what they voluntarily resolved to reach a resolution? And you can sense from my tone, I have a very strong feeling. I don't think they have any role in doing that whatsoever. That was what the parties dealt with through their counsel, assuming they had counsel that was there. And similarly, in the United States, in every case I have handled, that we bring it either in federal court or state court to have the judge turn the settlement into the force of judgment, so it's final. The judges have not stepped in to interfere unless they had some reason there was a conflict with the law. So that's the practical side of it. I don't know how it operates in Poland, whether the judges would be more inclined to become involved. I will tell you, this came up in some discussion I had with your judges here, and I did get at least some individual agreement that the judges need not know what the terms are in detail. in order to give their approval of a settlement agreement that comes out of mediation.
So there's another question up here about, is confidentiality compulsory? So I want to distinguish two things about confidentiality here. So the mediation process in our system, and really pretty much throughout the world, there are ordinarily statutes that provide that whatever is said inside the mediation process is confidential, and the idea is to create an environment in which people feel more open in talking about their problem, and they can be assured that if the case does not settle, that the things that were said in the mediation aren't later going to be used against them in court, or that the mediator would somehow have a role later on in the court. So mediation is compulsory in that sense, that the mediation process itself is designed to be confidential.
Confidentiality is compulsory.
It's compulsory.
It doesn't. Mediation does not work if it's not confidential,
Correct.
because you will never tell the mediator anything about your client or your case
Right.
if you're worried that at some place down the line that's going to hurt your client.
So, for example, in the statement we heard Vic deliver, among the things that he, at the beginning of the outset of the mediation, he acknowledged that there was some validity, that he had respect for the other side's views, that's how they saw it, and he apologized if they were hurt by it. Mm-hmm. Now, he's not going to say that if somebody could turn around and then say, "Oh, but you said in the mediation, this is what you acknowledged," even though it's not much of a, in truth, it's not much of an acknowledgement. You would never get a lawyer to take the approach that we've suggested is the best approach to take in the mediated environment if you were concerned that those words could be turned against you later on in a court proceeding. So the confidentiality of the mediation process itself is really extraordinarily important.
I'm sorry.
But what I wanted to say is that is distinct from what Vic was talking about before, about the notion that inside the mediation itself, in some circumstances, the parties come to an agreement that they want to keep the results of the mediation confidential. And they don't want anybody saying, "Well, how much did you pay?" or all of that. That's a part of the bargaining. And sometimes people reach agreements that they want the terms of their settlement to be confidential. Other times they do not want it to be confidential, or once they haven't reached agreement about that. So it is certain the result of the mediation process, the actual terms of the settlement, may or may not end up being things that are kept confidential or things that are made public.
Although I guess if they need the approval of the court, it's going to be hard to keep the terms confidential if they have to reveal them to the court.
Right.
But the court still can maintain some restricted access to that information and preserve confidentiality at various levels.
Like if they file it under seal.
That's right. They file it. And I've had cases in which we've done that, where we're dealing intellectual property issues that they don't want the terms of the intellectual property to be compromised at all. It's not uncommon to see that. The other thing that I wanted to point out is that it's not uncommon where the parties reach what we call a confidentiality clause. The typical clause will say the parties each agree that the terms and conditions of this settlement will be strictly held confidentially to the parties, will not be discussed with anybody else. Should there be any inquiry by others in our respective companies or families, or by the public on the outside, we agree to the following statement. And we actually put what the statement is, which usually is words to the effect, the parties have now reached an amicable resolution, and they are pleased to report that they are able to go on, and they might describe with a future business relationship or to go on in their respective endeavors. And what we add in these settlement agreements to give teeth to this is a punitive damage clause, which basically is, if you end up revealing in violation of that clause, each violation triggers, without a debate as to whether you should or shouldn't have done it. It's strictly very straightforward factually. If you reveal, there will be a penalty of X. And it's not uncommon for me to have negotiated with an employee and their representative. If the employee goes out and talks about anything about the terms of settlement and it binds the company to anyone outside of this mediation, it will be $10,000, $20,000. I had a case not that long ago before I retired, $100,000, because we knew there were a whole bunch of people waiting in line to see what was going to happen here, and we did not want this to be used against us. So there are all kinds of ways to give teeth to these confidentiality clauses.
But that's all a question of the bargaining. It's one in the mediation, and
Absolutely.
that is not in any way compulsory.
That's correct.
And and the plaintiff could say, "No, we won't agree to that."
That's right.
And that's just part of the bargaining that could take place in the mediation. It looks like there may be some other questions here, so let's move on and take.
Is it common in the United States to propose new solutions by mediator to the party? Which one of you like to take that first?
You want to start,
I'll
Claudia?
take it. I think there are some mediators who never would. I think there are other mediators who, in the first instance, will always try to draw the solutions out of the parties, but who will say the parties are really stuck and they're not coming up with any ideas. Then the mediator might say, well, what do you think about this? Do you think this as a solution might work for you? And if they say yes, they could talk to the other side and say, well, what do you think? Is that a solution that might work for you? So I think at the end of the day, many mediators would propose some solutions. Obviously, the parties have to agree to them. The mediator can never impose the solutions. But I do think that most mediators in the first instance would like to draw it from the parties, for the reason that when the parties think of their own solutions, they're more bought into them and they're more likely to abide by them and to think that it's a good solution.
The other concern, so I agree with everything that Claudia said, and certainly that is in accord with my own practice, that I will propose new solutions, but I always want the parties to go first. The problem for some mediators when the mediator starts proposing solutions is that the mediator can become attached to their own idea. And then if the parties don't like the idea, the mediator might still try to press it on them. So in training mediators about this, I always emphasize that mediators, if you're going to propose a solution as a mediator, you have to make sure that you do it with some humility. And that you don't become so attached to it that if it doesn't really work for the parties, that you don't find yourself still pressing them on
and you only do it after you really know what they want.
Right.
So you really understand their needs and their interests, but they're, for whatever reason, having trouble coming up with a solution to meet their needs and interests. You could never do this until you've truly understood what matters to them.
There's some areas that it's very easy and appropriate for a mediator to play a role here, and there's some areas that it's not. Where it's easy, for example, let's say they're arguing about a large sum of money. It may be that nobody's thought about it. You get a demand for X number of dollars, and you as the mediator say, well, and the other side says, look, I just don't have the money and I can't afford it. It is total, in my mind, and I'm sure my colleagues would agree with me, to suggest, well, can we consider, do you want to consider staggered payments? So instead of it all be due within 30 days, it may be something over a period of years. And then it may be, well, I don't know if I'm going to be able to get it. And you may suggest, well, we could put the money in a trust fund where it's reserved. So the money is set aside, you know it's there, but it only has to be funded over a period of time. These are the kinds of things that I think a mediator, without showing a bias, facilitates it to be a resolution that can really work. The one thing, and I think we've mentioned this now, that I have very strong feelings about, and Howard and Claudia may have a different cut on this to some degree, is the one thing I never like answering and never will answer is, what do you think I should do? Do you think this is fair? Do you think I should accept it or not accept it? And when it comes to something like that, I feel very strongly that I will not answer to them what I think about the resolution. I turn it back to them and say, look, what I think is really not important. What is most important, it's voluntary from your perspective. You are comfortable with it and you are willing to go forward. Because if that is the case, those criteria are met, then that's exactly what you should do. But if not, then you shouldn't. And that becomes a decision that you need to make, and that's in your own interest. That's really important. The danger, of course, of a mediator in their anxiousness to get a resolution of indicating whether they should or shouldn't, as you can appreciate, then you lose, I think, a significant amount of your neutrality.
We should move to a next question because I see that there's more lined up here.
How do you see the parties and their lawyers manage assessing and negotiating the value of their claim and getting to the satisfying solution in cases which are 50-50 ones? Calculation of chances in court is very difficult. Presenting the cost and time, the cost and time of the court litigation helps, but the difficulty of establishing who is actually right creates a very sensitive situation. What would you say is crucial in such a mediation?
You want to do that one?
Well, this is a very good question, and it is not an uncommon occurrence that this is how the parties look at things. The first piece that I would say is that I want to explore I want to explore with the parties as much as possible something beyond the risk analysis, because this question is centered around how the parties are thinking about the risks of going forward. And so the first level is about trying to draw attention to underlying needs and interests, which may not just be based on the calculus of who's right or wrong in the dispute. To make sure that we've got to try to get more to work with than just the difficulties of what's likely to happen in court.
And to underline that, some of you may know this, but there's a story about two girls fighting over an orange. There's one orange left in the kitchen, and both girls want it. And so the mother's idea is she's going to cut it in half because each girl has a really good reason why they should get it, and she can't decide. And so she's going to kind of cut it in half, and each girl gets half of the orange. So that's the 50-50 split that you're talking about. And so in that instance, each girl basically gets half of what she wants, and the mother thinks it's a fair settlement. But if the mother had inquired to the girls, well, why do you want this orange? She would have learned that one girl wanted the rind to grate into a batter because she was making a cake. And the other girl wanted the juice because she wanted a glass of orange juice. So had the mother inquired about the underlying needs and interests, she could have said, oh, great, girl number one who wants to make the cake, take the rind, grate it, and then we'll give the orange to the girl who wanted the juice, and she can make juice. We'll give the rest of the orange without the rind to the girl who wanted the juice, and each girl gets exactly what they wanted. So obviously, many cases don't work out quite as neatly, but this is an example of what Howard's talking about not looking at just who's right and who's wrong, or how do we compromise the situation. But if we look at the underlying needs and interests, maybe there's a solution that can satisfy both sides equally.
Without getting into detail, given the scope of this presentation with you, I do want to just mention what Howard alluded to. The other way that we try and analyze this, we set up a decision tree, which is basically we take a look from each side's perspective of what is the likely outcome to occur first at the, if you will, the trial level, then the appellate level, and then the further appellate level. And what a lawyer will do, particularly if they're represented by a lawyer, will do with the mediator is sit down and look at similar cases, see what the likely result is in the case, come up with percentages of what that likelihood is, And so if they're asking for a certain amount, let's say, for just to pick a number, $100, and it turns out it's a 50% likelihood, then to say, well, given that there's a 50% chance that you may lose this case, it's reasonable to reduce the amount that you're demanding by a certain amount, and then take it through each stage of that kind of a decision tree with appeals and all the rest. That is very acceptable to many lawyers and to business people in a client representation context. So there are many different approaches that could be done along these lines that help the parties move off of their hard positions to some kind of a good faith compromise.
I guess the only other thing I would add is that in my experience, most counsel overestimate their own case. So the other technique for both sides is to really try to focus them in on, is it truly a 50-50 kind of a proposition? And I will admit that one of the tools I would use is to work with in both sides to try to sow some additional doubt about how folks are actually looking at their claim. But it is a difficult situation, and sometimes the assessments are such that the gap can't be bridged. So we should move on.
Okay. How do you see?
No, we just did that one.
Okay.
The next one.
You have met with judges. What is their attitude towards mediation? What is the problem that they do not refer cases to mediation?
Right.
Oh.
Good question.
We set up that question. I'm going to be right back. Go ahead.
Okay. So we did meet with, we met with about 70 judges from the district courts and the regional court. And I would say, and then we had a meeting with about 20 judges and court administrators. The 20 folks we met with in the afternoon were extremely supportive of mediation. We're actually very interested in seeing it grow and expand. And so my personal opinion is that there is quite a core of judges in the court that are very interested in it. And they need your support. And, some of their colleagues are probably a little less interested. Do you have?
No, I think that sums it up. But that we were pleased with the amount of interest we saw from the judges in general, and particularly with the group that Claudia mentioned in the afternoon, at their interest in increasing the number of referrals. I also wonder, in our system, and again, this may be different for you folks, it's certainly helpful for the judges to refer cases, but the participants are free to go to mediation without a referral. So, the other way to drive this is as legal advisors yourselves, even without a court referral. We have yet to hear that there is some impediment to your reaching out to the other opposing side's advisor and agreeing on your own without the court referral to go to a mediation. And, I appreciate that there could be, that it may take some time to develop that sort of culture. But unless there is some rule that says that you can't, if you're interested in mediating the case, you don't have to wait for the judges. And there, in the U.S., there certainly has over the years been a dynamic interaction between the judges referring cases and people simply agreeing privately to take their cases to mediation.
One of the things that we urge the judges to do is to create focus groups or groups of stakeholders, which include you, the lawyers, to talk about how to develop mediation. And to the extent that you have any bench bar get-togethers or have any ability to influence that, I would highly suggest that you work on really promoting that and promoting some kind of a bench bar and maybe business community as well, to be a group that supports the development of mediation in the courts and in POSAM generally.
Okay.
Have
Is that it?
have we
Have we
questions?
exhausted the questions? All right. Well, once again, we just would very much like to thank all of you for your active participation and for the good questions throughout. And we wish you all of the best in moving forward with the development of mediation in Poland as a whole and here in Poznan in particular. And we thank you for your participation and your attention.
Yes, thank you very much. I personally am sorry that we really didn't get to see you, see your faces, but we know you're out there and appreciate the questions and really appreciate your time and interest.
Thank you all very much. Okay.
It's okay.
There we-
Oh,
here we
thank
go.
you very
Thank
much.
you.
That's
We're getting some thank yous. That's okay.